Are embryos babies? Should a small cluster of cells be given the same legal protections as a fully birthed child or a fully grown adult? One US court ruling says yes. And if you're familiar with it, you might be saying to yourself, only in Alabama. But the combination of the new Trump administration and conservative courts means there are a number of ways to restrict reproductive care across the US, even in blue states. These policies are pretty unpopular, but Trump and his Republican allies are driven by a base that holds an extreme view on protections for embryos and fetuses, at the expense of the people who carry them. There's a lot to cover. Here in part one, we'll see just how far anti-reproductive activists have advanced so far, and the lengths they'll go to prevent democratically enshrined protections for reproductive care. In part two, we'll look at how much farther they could go in the Trump administration, including how they'll bring about their ultimate goal of a constitutional, nationwide ban on abortion. We'll talk about all that right now on The Politics of Democracy. First, background. Most people are familiar with Roe v. Wade. We need to understand what it did if we want to understand how it's being undone. In the 1973 ruling, the US Supreme Court found that until a pregnancy is viable, which varies widely but is often around 24 weeks, the state couldn't play a role in restricting access to abortion care. Even after that, abortions must be allowed to protect the patient's life and health. Keep that word health in mind. It's going to become a really big deal here. The legal discussion began to move away from viability toward when life begins in 1989, when the Supreme Court upheld a Missouri statute that defined life as beginning at conception and made doctors perform a fetal viability test if someone wanted an abortion after 20 weeks or more pregnant. Chief Justice Rehnquist wrote in his ruling, "We do not see why the state's interest in protecting potential human life should come into existence only at the point of viability. There are years and years and years of legal battles and legislation between that ruling and the one that overturned Roe v. Wade in 2022. That decision, Dobbs v. Jackson Women's Health Organization, effectively allowed states to ban abortion at any stage of pregnancy because it said there's no constitutional right to an abortion. The life begins at conception idea took a pivotal turn in February 2024. The Alabama Supreme Court ruled that frozen embryos are essentially children in the eyes of state law. In that case, couples who had undergone in vitro fertilization, or IVF, had embryos stored at a facility in Alabama. When the embryos were accidentally destroyed, the couples sued for wrongful death. The Alabama Supreme Court found in the family's favor. But how? Well, in 2018, a state constitutional amendment passed that said it is state policy to recognize and support the sanctity of unborn life and the rights of unborn children, including the right to life. Citing this, the court found in the parents' favor. The ruling describes the destruction of embryos as killing them, and in Chief Justice Tom Parker's concurring opinion, he says, "Even before birth, all human beings bear the image of God, and their lives cannot be destroyed without effacing his glory." The ruling led to a temporary suspension of IVF services across Alabama as clinics tried to figure out what it meant for them. Then presidential candidate Nikki Haley first seemed to embrace the decision and said, "Embryos, to me, are babies." Now, this local eruption was quickly resolved when Alabama passed a law to protect reproductive care providers from liability or criminal prosecution for the damage or destruction of embryos. But even that was a problem. A coalition of groups that believe life begins at conception asked Alabama Governor Kay Ivey to veto the legislation, arguing that it will affect the millions of human lives, the embryos, who face being discarded or frozen indefinitely. Before we dig deeper, this story focuses on some Christians' views of abortion, reproductive rights, and related care. But let's remember, your religion doesn't decide how you feel about reproductive care. For example, one survey found about 50% of Catholics in Arizona believe that abortion should be legal in most cases. People of other faiths have even challenged strict abortion bans, arguing that these laws blur the line between church and state and impose a Christian interpretation of when life begins on everyone else. And not all religious people want to impose their view on others. There are those who practice their faith and believe everyone is entitled to believe and do what they want. Crazy idea, right? But then there are those who think they have a monopoly on divine wisdom. They believe their God is the one true God, their religion is the one true religion. These are the ones, no matter what religion they belong to, that want to enshrine their religious beliefs into laws all of us must live by. Those are the folks we need to focus on today, because at least as far as abortion care goes, democracy is an impediment to their goals. The subset of Christians who want to restrict access to reproductive care and use a religious basis for it say something close to what the Danbury Institute says, an organization Donald Trump addressed during his re-election campaign. They say, "We are Christian. We believe the scripture is authoritative, inerrant, infallible, and sufficient for life and godliness. Further, we believe the greatest atrocity facing our generation today is the practice of abortion. Child sacrifice on the altar of self. More than 60 million preborn humans, each wonderfully made in the image of God, have been murdered on our watch. Abortion must be ended." Does Trump agree? In campaigning for the 2024 election, he said he thought banning abortion after 6 weeks was too short, and implied he'd be voting in favor of a referendum to expand access in his home state of Florida. That did not last long. The next day, after facing criticism for supporting IVF and threats to vote for write-in candidates, he announced he would vote against the referendum. He's never maintained a stable position. In 2018, he said he supported a federal ban at 20 weeks. By 2024, that was down to 15. Then he said he would veto a federal ban and said it should be left to the states. But why all this waffling if a core part of the Republican base, the anti-abortion voters, are so strongly and clearly positioned on one side of it? Turns out, abortion restrictions aren't very popular, even amongst Republican voters. And that unpopularity has led Republican lawmakers and their anti-abortion supporters to manipulate the electoral system to attempt to keep access to reproductive care off the ballot entirely. Let's look at a few examples. By the way, I'm not even going to get into all the lawsuits the pro-reproductive rights side had to navigate to get their signatures counted and get on the ballots. We literally do not have enough time on all of YouTube. But a board member of Arizona Right to Life explains their goal with the lawsuits. "We are working to make sure it doesn't get on the ballot in the first place. And considering their track record, that might be their best hope at winning." We'll start with public support, especially Republican support in Kansas. In 2020, Trump won 56% of the vote in the presidential election. 2 years later, there was a ballot initiative that asks voters to affirm the state constitution did not protect the right to an abortion. They lost and only got 41% of the vote. This was the first bit of evidence that conservative-minded voters were not willing to go as far as the anti-abortion movement wanted to. Next came Ohio, the state famous for forcing a 10-year-old rape survivor to go out of state for an abortion, then calling the story a fabrication before arresting the perpetrator. When it looked like a ballot measure expanding access to abortion might get on the November 2023 ballot, anti-abortion Republicans tried to change Ohio's referendum rules. They used their majority in the state legislature to schedule a referendum for August of that year to raise the threshold for future ballot measures from 50% to 60%. They failed, collecting only 43% of the vote. The November amendment to protect access won by 56%. No side got 44. A year later, Trump captured 55% of the vote in the presidential race. In 2024, a number of similar referendums were held across the US. Down south in Florida, there was an attempt to override the 6-week abortion ban the state legislature had passed. In one ad supporting the Yes campaign, Caroline describes how she was diagnosed with brain cancer, that without an abortion she would have lost her life. And her daughter, of course, would have lost her mom. She says Florida's new ban would not allow exceptions in cases like hers. The Florida State Health Department sent cease and desist letters to stations airing the ad, threatening them with criminal charges. The Yes campaign sued, and the court sided with them, telling Florida not to continue the intimidation. the presiding judge distilled his wisdom thusly. To keep it simple for the state of Florida, it's the First Amendment, stupid. The measure failed because they only got 57% of the vote. Yes, that's right. I said 57%. 57% of voters in Florida voted to lift the ban and extend protections, but Florida's threshold for constitutional amendments is 60%. By the way, Trump won 56% of the vote in that same election. In Arizona, only 38% of voters voted against a constitutional right to an abortion, while 52% of them voted for Trump. That was only after Republicans tried to use what is supposed to be a neutral voter guide to say the amendment would allow the abortion of an unborn human being, rather than using the word fetus. A judge forced them to fix it, calling the term packed with emotional and partisan meaning. In Missouri, an abortion ban came into effect in 2022, limiting the procedures to emergencies only. Dr. Betty Wickstrom, an OBGYN specializing in high-risk pregnancies, knocked on doors to see the ban overturned through a 2024 ballot initiative. She often has to send her patients with ruptured membranes out of state for abortion procedures in the second trimester, unless she wants to go to prison for 15 years. When the fetus has a heartbeat, she has to consult a lawyer before proceeding. Dr. Wickstrom is quoted as saying, "Bleeding, infection, labor, all of those things can happen with or without the heartbeat stopping inside the womb. You've got to stop the pregnancy and empty the uterus. You have to take care of this woman, or she potentially dies." In a letter signed by 800 medical professionals, including Wickstrom, they say women are denied abortions and forced to continue life-threatening pregnancies, risking their health and their lives, and that they can't treat their patients with heartbreaking pregnancy complications until they are on the brink of death. So doctors can't act to preserve the health of the mother under life begins at conception, only prevent her death. Back to the ballot measures. Missouri Secretary of State Jay Ashcroft drafted language for the ballot question that would have asked Missourians, in part, if they wanted to allow for dangerous, unregulated, and unrestricted abortions from conception to live birth. That was after he attempted to decertify the measure to keep it off the ballot and had to be told by the Missouri Supreme Court to put it back on. The measure passed 52% to 48%. Trump won by 58%. Similar measures passed in Montana and Nevada. All of these show similar splits amongst the electorate. People voting for a Republican president while also voting to enshrine reproductive rights into law. There were two outliers. Majorities in Nebraska and North Dakota voted to restrict access. So, a lot of laws and ballot measures focus on the number of weeks of gestation, or the idea of fetal viability. But those laws can't take into account all the medical circumstances a patient might face throughout a pregnancy. They limit access to care for patients facing incredibly difficult, often urgent circumstances, and prevent a patient from reaching their own decision with their care provider. Also, there's no strict medical timeline for viability. The American College of Obstetricians and Gynecologists strongly discourages the inclusion of viability in legislation or regulation. They point out rates of neonatal survival range dramatically from 23 to 27% for births at 23 weeks, up to 76% for births at 25 weeks of gestation. Many of the laws, even the more expensive ones, still imagine there's some role to play for the state in deciding when a pregnancy can and can't be terminated. That's bad policy decided by the wrong people at the wrong time with the wrong information and the wrong skills. And there are other harms to carrying an unwanted pregnancy to term, by the way. The American Psychological Association cites a study that found women who were denied an abortion reported more anxiety symptoms and stress, lower self-esteem, and lower life satisfaction than those who received one. And we haven't even started talking about the fundamental right to control one's body. So, a few conclusions to draw from this. 1, the anti-abortion side, including lawmakers, are happy to circumvent democratic will to prevent people from accessing abortion care. 2, Winning referendums to protect access is only the start. Considering the court battles to even get these things on the ballot, we should expect more lawsuits from the anti-abortion side. 3, I hinted at this at the top. What comes next is the tricky part. In the states with Republican-led legislatures, we'll have to pay close attention to how those laws are written. They could impose strict regulation on access, say limiting who can provide the care and under what conditions. The laws could make it essentially too onerous or too dangerous for care providers to perform abortions in their state. Finally, all of this ballot support for abortion access may come to mean nothing at all. In part 2, we'll talk about the federal level and the tools available to the Trump administration to prevent access to abortion there. And as we'll see in part 2, they have a path to get this read into the Constitution. Until next time, I'll see you in the comments.